I had a professor in law school say, start on time, end on time. And I'm going to do my best to live by that maxim and go through this relatively quickly. Two components to the talk today: enforcement of IP rights. We'll talk about general trends from a U.S. perspective, and then some risk mitigation strategies that can be employed broadly, but also in the automotive industry. You'll see a continuation of themes from what you've heard from my panelists today in certain areas. So just in general, in the United States, there's just far less patent lawsuits being filed. Unified Patents estimates that the number of patent lawsuits filed in district courts in the United States has decreased by 35% in 2 years. That's quite a dramatic drop in patent litigation. Some sources or some articles suggested that within that there are also fewer non-practicing entity plaintiffs today than there were at just a short time ago. So those are sort of broad trends that are happening in patent litigation. Automotive patent litigation, I think, has tracked just general patent trends. When you have a 35% decrease in overall patent litigation, there's not one sector of one industry that won't feel that drop. However, most of the patent litigation in the automotive sector is still attributed to non-practicing entities. Unified Patents suggests that's 80% MPE, 20% operating companies, meaning only 20% of these litigations involve operating companies that are either plaintiffs, so to speak. So that's one trend to think about when you're developing these products and you're implementing these new technologies. It's not the be-all, end-all of your risk strategy, but the likely type of patent litigation that you're going to be involved in, at least in the U.S., is likely maybe NPE type of litigation as opposed to OEM and supplier litigation. And then we'll get into, towards the end of the presentation, how you might address those different players as you enforce your rights. So this is some historical just anecdotes. IP enforcement in this space has involved a wide range of technologies: multimedia, infotainment, safety features, conventional vehicle components, autonomous technologies. Some of this is historical. Some of this is related to the rights that the types of patents that MPEs are going to enforce. So what are some predictions? I would say IP disputes in the automotive sector will probably increase moving forward. They'll involve multiple types of IP disputes. It won't just be about patents. It'll be about patents and trademarks. Shankar mentioned the Waymo Uber dispute. A big part of that case was also trade secrets. So that's also important to know. Why will these disputes increase? You'll see, like you've seen today, there's a lot of technological convergence in the automotive sector. And when you have this technological convergence, sometimes our IP regimes don't quite catch up to those as fast as our innovators do. And you get maybe healthy debates about where these different rights overlap or where they distract or separate from each other. New players in the automotive industry. We saw the value chain, I think, reflected how much it's changed in the last 10 or 15 years. I read the other day that Intel is now a tier 1 supplier. I don't think 15, 20 years ago we would have said, Intel is going to be a tier 1 supplier in the automotive industry. Google and Ford was mentioned earlier today. There's just a lot more and different types of participants in the automotive industry than there were. My colleagues also talked about the increased patenting levels in automotive technology. You put these three things together, and that's probably will lead to maybe increased disputes. How they are resolved. Does the automotive industry take the approach that has happened historically, where maybe OEMs or suppliers have not rushed to file suits, or will there be more more OEM suppliers as plaintiffs in these litigations moving forward. So against that backdrop, where do you go with risk mitigation strategies? I've heard in several other presentations during the talk today is whatever you do from an IP risk mitigation strategy, it should be part of your broader IP strategy, and that should be part of your broader business strategy. It shouldn't be I guess addressed in isolation apart from what your business is doing. One important thing I just want to mention, clearance. That should be commensurate with the rights involved. So I think there's patent clearance is fairly, I don't want to say it's straightforward, but we know how to approach freedom to operate studies and patent studies. But often there will be other rights at play. There'll be copyrights, there'll be trade secrets. In the jurisdictions that have protections for data, there'll be that. Risk mitigation, I would also extend into your litigation strategy. Often, companies don't necessarily want to find themselves in the middle of patent litigation. Sometimes they're a defendant, sometimes they're a plaintiff. In the situations where large companies are a plaintiff, maybe they choose to be there because there's something important at stake and the market dynamics require it. But you often don't choose to be in some sort of litigation at the time. So how you approach your litigation strategy, I think, could also be a way to minimize risk moving forward. Moving on, what are some risk mitigation strategies? I think these things you've heard, I think they shouldn't be a surprise to the practitioners in the audience and on the panel. I'll go through some of these relatively quickly. Freedom to operate studies. They're still valuable. They're still useful. I still advise my clients to do them in certain circumstances. Often the question on freedom to operate studies is, when do you do it? Do you do it when you have a concept, or do you do it closer to commercialization? Well, the lawyer's answer is somewhere in between. But when you do that is really dependent on, I think, the nature of your business. I put here employee hiring exit practices. Employee mobility is a big issue. Especially when it comes to trade secrets. I'll refer to Waymo v. Uber. That was essentially an employee mobility case in large parts. Patent pools, patent acquisitions, strategic partnerships we've heard about, and again, litigation strategy. And let me just run through a couple of these quickly. Why conduct an FTO study in the first place? I advise my clients there's two reasons you do that. One, it's a business tool. Companies want to know, is my product going to infringe a patent? Or is my product development pathway in line with a low-risk position? The only way you can do that is if you assess sort of your patent risk in that environment. The other reason you have an FTO study or a written opinion of counsel eventually is a legal tool to limit damages in response to a willful infringement allegation. Those are the two reasons why you would have it. Both are valuable, but I think my clients practically just want to know, do I infringe or not? Do I have to change a process? Is there some design around that we have to do in this context? This is a flow chart. I find it helpful. If you divide your freedom to operate studies into different phases, sort of what are the broad areas that you need to focus on, and then how do you get down to this, usually the 3 or 4 issues or IP rights that you really have to be strategic about how you're going to address. This flow chart involves patents. I wouldn't say this is repeatable in other types of IP regimes, but I think this phase analysis is a good way to look at it, and probably would follow some stage gate type innovation strategies that companies would employ. Employee hiring exit practices. So 2 things I just want to mention. Consider non-compete obligations for important hires. That may not be important in certain jurisdictions, but in the United States, there are non-compete agreements that are enforceable, and maybe there's some representations that you want your important hires to make if they're subject to employee contracts. The other thing that I think you can do on a more proactive basis is just consider trade secret audits. Okay, what are you doing to ensure that your trade secrets are being maintained? Okay, and how can you address the gaps? Now, how does this relate to employee mobility? Well, if trade secret protection, at least in the United States, and it generally protects secrets that are valuable and things that you have taken reasonable steps to keep them secret. Okay, if you don't try to keep something secret, you're going to lose the trade secret protection. Hence, an audit could help uncover areas where you might be lacking in maintaining your trade secret protection. That becomes important if important employee A goes to competitor 1 and you haven't taken adequate steps to protect that trade secret protection. You've lost out on a claim that you may have, or at least some leverage in the context of that employee moving. Something to, I think, to keep in mind. Patent pools, patent acquisitions, I wouldn't maybe classically put this in a risk mitigation strategy, but it is a tool that I think can help you in a litigation context. If you have access to other patents and other enforcement rights, it helps. It helps how you approach the litigation. It helps in negotiation, moving forward. Acquiring patent portfolios for defensive purposes is very similar. Finally, strategic partners. This should be intuitive. You identify partners with significant technological and IP holdings. I think that the industry is doing that. We're seeing this manifest itself in large IT companies partnering with automotive manufacturers. In my view, this is a mechanism to share risk. You have a shared fate, so to speak, in the technology that a group of companies have chosen to adopt. The IP agreements, of course, that go into those partnerships and the partnerships that you're going to have forward are really, really important and critical. These agreements will define how enforcement is going to be handled, how costs might be handled, what do you do with patent prosecution costs. A whole number of issues come up when you have these strategic partnerships. And I'm sure attention is given to this, but it's worth saying again, strategic agreements of this nature are just really, really important to look at. Okay. Like I said, I was going to